Ladies and gentlemen, buckle up. This is where things get interesting. Miguel Angel Ramirez Galvan is about to face the consequences of a charge that might sound small on paper, but in reality, it can wreck lives. Less than 1 gram of a controlled substance sounds minor, right? But under Texas law, this is a felony. That means potential prison time, thousands in fines, and long-term consequences like deportation if you're not a US citizen. Already, the stage is set for high stakes. And notice how carefully the court brings in an interpreter. This isn't just formality, it's a safeguard. Because if a defendant doesn't fully understand the process, every single ruling could later be challenged. Think about it. Would you trust your future to a courtroom where you don't understand the language being spoken? Let's see how this unfolds.
All right, court is calling 2025 CR 008466. State versus Miguel Angel Ramirez Galvan. Can I have parties announced for the record?
Megan Galloway for the state.
Alfonso Otero for Mr. Galvan.
And are you Mr. Galvan?
Yes.
All right, we have an interpreter here. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
Yes, John.
All right, you may lower your hand if you'll state your name for the record.
Yes. Jacqueline Payan.
All right. Mr. Galvan, all of the records that I'm going to review with you are in English. Were those explained to you in Spanish?
Yes.
Yes.
All right, so I know that in Spanish, the little Spanish I do know, I know that yes is in English, and I know in Spanish it's sí. Am I incorrect?
Correct.
So either we're going to use the interpreter or we're not going to use the interpreter. Do you understand?
Oh, sí.
Yes.
Okay. Counsel, do you speak Spanish?
I do, Judge.
And do you speak it fluently?
I do, Judge.
And were you able to explain these documents to your client in Spanish?
I will, Judge.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Judge.
Okay. Mr. Galvan, have you reviewed the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
All right, so you're gonna have to wait till the interpreter interprets before you answer. Understand?
Yes.
All right, counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Here comes a fascinating twist. The state decides to drop the bigger charge and move forward with a lesser offense. Why prosecutors often do this when they know the evidence on the higher charge might not hold up. It's like hedging their bets. They secure a conviction without the risk of losing outright. But don't think this makes it easy time. Even this lesser charge carries up to 2 years behind bars. And here's the kicker. Once you're convicted of any drug-related felony, the label sticks. That shadow follows you into job applications, housing opportunities, even your immigration status. So let me ask you, is this really a favor to the defendant or just a clever way for the state to lock in a guaranteed win?
No, Your Honor, the state moves to proceed on the lesser included offense of possession of a controlled substance, PG1, less than 1 gram.
Any objection?
No, Judge.
Yes.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Court is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Galvan, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a US citizen, by entering into this plea, you could be deported, denied naturalization?
This is the moment that hits hardest. The judge lays it out plain and cold: plead guilty, and you may be deported. That's the hidden landmine in cases like these. For non-citizens, even a minor drug conviction can mean permanent separation from your family, your job, your entire life in the US. Imagine standing there, knowing a single word, guilty, could end everything you've built. And yet, watch closely, the defendant answers yes without hesitation. Is it resignation, trust in the system, or just the pressure of the moment? Think about what you would do if faced with that choice.
And denied re-entry into the United States.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at an $800 fine, 149 days in the Bexar County Jail under 1244, taking consideration 2025 PF 16342. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then how do you plead to the less included offense of possession of a controlled substance, penalty group 1, less than 1 gram?
Guilty.
State, any evidence?
State offers states 1 and attachments.
No objection, Judge.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge. Just reversion.
All right, as previously stated, the court will find you guilty. The court will sentence you to 149 days in the Bexar County Jail under 1244. There's an $800 fine. Time and money will run concurrently. Taking consideration 2025 PF 16342, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, You do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
And just like that, the sentence is locked in: 149 days in jail, an $800 fine, and a felony conviction stamped onto his record forever. But notice how the judge doesn't just stop at the punishment. She turns into almost a counselor, warning him that addiction has only two exits: prison or death. It's a rare glimpse of compassion in a system that usually feels cold and mechanical. But now I want to hear from you. Do you think the judge's warning will make a difference? Or is this just another case lost to the cycle of drugs and punishment? Let us know in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what's coming next.
Yes.
All right, we can go off the record. Here's the thing. If you're using drugs, only one or two things going to end up happening. Either you're going to end up in and out of somebody's jail or prison, or either the last time you use is going to be the last time you use, and somebody will have to identify your body. So if you have an issue with drug addiction, you come back to court, I'm still here. I'll pick up the phone and find a place that can help you, okay? All right, good luck to you.